The net investment income tax. This isn't something new. This has been around for years now. I call it the Obamacare Medicare tax on non-working income. One nice thing about it is it doesn't affect a high percentage of taxpayers because you're not subject to it until your gross income is up to $200,000 individually or $250,000 married filing joint. So it is limited there. But it does hit capital gains, interest, dividends, rental properties, passive activities. One of the things I've seen is maybe someone has a piece of property that they've had for years and years. All of a sudden they sell it, they have a big gain on that. That gain adds into your gross income and now probably subjects you to that 3.8%. Some of these things in the rental properties and capital gains and stuff are not subject to it. You can exclude them for certain reasons. We try and ensure with all of our clients that we make sure if it isn't subject to it, we don't charge you the tax on it. So, and it has been around, and it really didn't change with the new tax law, but because of what Lisa just talked about, losing some of our itemized deductions, your investment interest expense, if you're taking the standard deduction, your investment interest expense, your property taxes on investment property that used to reduce your net investment income are not deductible. So you don't get to take that deduction against this tax. So anyway, I want to move on and discuss one of my favorite topics, estate and gift taxes. And there were some significant changes in this. As you can see, in 2019, the exemption's $11,400,000. Today, 2020, that's up to $11,508,000. And what that is that's the amount of assets you can have when you die or can give away before you die without being subject to the estate tax. So that's very high now, and it really doesn't hit very many people. But I won't ask by a show of hands, but if anybody is in that range, let me know. I'm available for adoption or marriage. So that doesn't really help us as much. But be aware that that increase with the new tax law, it gets sunsetted. In 2025, it drops in half. It goes back to the old rates, which are indexed, but basically cuts in half. So if you're up in that area, there may be some considerations to do some extra gifting before 2025 to get it out of your estate. 2019 and 2020 annual gift exclusion is $15,000. You can give anyone $15,000 a year without using up your exemption. If you go over that $15,000 to any individual, you're supposed to reduce your $11 million lifetime exemption by that amount that you're over. Bear in mind, that gift is not a tax deduction. I'm sure I get asked 2 or 3 times a year, if I give my son or daughter $15,000, how much will it save me in taxes? Well, it doesn't save you in taxes. You don't get to deduct it, and your children don't have to pick it up. Well, it comes out of your assets, which if you make money, you're paying taxes on it to build it up and give it out. So you just don't get to take a tax deduction for it. You don't get taxed on it. He does not get taxed on it. If you give him $15,000, you don't deduct it, he doesn't pick it up as income. These TVs are going back and forth. See on it. I think this is the big place. Estate planning, it's more than minimizing estate taxes, because a lot of us are not going to fall into this one and pay 40% on the excess, at least not at this time. But that estate tax is not the only thing to plan for. First of all, I recommend that everyone have a trust and a will, have things in place for your descendants, for your spouse. Make it easier on them while they're in the grieving. And the next thing is That trust, those documents need to be reviewed periodically. Every couple of years you should sit down with them. Now is a good time to sit down and look at those things. With the changes that are there and this high exemption, it's a good time to sit down. And I know a lot of you, when you do these trusts, the attorney and the accountant tells you, here's what you need, here's the document, sign it, let's go through, sign all these things. You may not really understand what that means. Most trusts with a husband and wife, upon the first to die, splits up. And there's a trust for the surviving spouse and one for the decedent's spouse, usually an exemption trust. And that has been the normal, and it still is, because what it does is helps with this $11.4 million. It doubles that for a married couple. But you may not need it so much anymore with other provisions that are out there. We still have what's called the portability provision, and that's where if you're married, your spouse passes away, and maybe the estate's only $1 million, and they use $1 million of that 11. If you do it right, the surviving spouse can get the other $10 million of exemption. So now that surviving spouse has $21 million exemption. So the other thing with just the split up is maybe when you sit down and look at it, maybe you got $1 million, $2 million, and half of that gets split off into a separate trust. Maybe you don't want your surviving spouse to have that set off and not have as much access to it as you'd want them to have. A lot of family situations come into play here. Is it a second spouse, age, is there going to be remarriages? But this is a good time to sit down and say, is that what we really want to happen? And when I say look at it, say, oh, my assets are worth $1 million. If I were to die, my spouse gets $500,000 of it over here that she can do what she wants with, but $500,000 over here that she's limited. You might not want that. You might want the whole thing to go. We still have what are Q-tip trusts, qualified terminable interest trusts, that you can incorporate in with some of this. Gives a little more to the spouse. Also, the exemption trust does not get a stepped up in basis in assets on the second to die. And that's been a big thing over the years, is a lot of times it's better to have that stepped up basis than to shelter it from the estate tax. Because you're probably not going to hit the estate tax now, but you're going to hit the income tax. A Q-tip trust is still included in the surviving spouse's estate, so it does get a stepped up in basis. And I'm sorry if I'm talking, if you don't understand anything, that's not bad. Talk to me in person. Talk to my partners in person, because we can explain it, and we know more of your situation than just an overall view.
The state tax exemption, 11.58 now, said in 2025 that's going to...
That's a great question, and I don't know that I can answer it. We were all around in 2010 when it sunsetted back from, in 2010, unlimited, supposedly coming back to $1 million, and we were all very worried at that point. They did come out and change that and increase it, not back to unlimited, but it did go up. I really can't tell you what the likelihood of that is. It's still going to be a fairly high one. It'll be about half of what it is at that time. So it's still going to be high, but half of what it is in 2024. So I don't know. I mean, we don't know what administration is going to be in there. We don't know what it is, but it's still going to be fairly high, so it's not going to affect a lot of people. But if you're up in those ranges above that $6 billion and things, this is a good time to be planning. Really, my biggest point is looking at your documents. I want every one of you to know, put pencil to paper, write it down. We have this much in assets. The trust says upon one of us to die, this is what happens. Do you want it to happen? Don't just go back to what your trust attorney and your accountant said, saying, this is the way we do it, this is the way we do it, everything's great, you're going to be fantastic. know what that means, because I've had, worked on several estates where they didn't really understand it. I had one that had a, is anyone here from Wells Fargo? I don't want to disparage Wells Fargo. They were doing what they did, but their trust split in half, and Wells Fargo was the trustee upon the death. Well, they called my widowed client and told her, oh, that house is in our trust. You either need to move out or start paying rent. None of you guys want that to happen. We were able to jump in and change trustees, but I'm just saying, know what's going to happen. Don't just let me as the accountant say, oh, let's split into this trust and this trust, everything will be great, you're going to save everything. Sit down and say, what do we have? What happens when we die?